Hello ladies and gentlemen, this is your host, Ahmed Mufas Sayed, coming at you from ECNA, European Criminal News Agency. Today we're going to talk about the Kadi and Al-Barakat versus Commission and Council case from 2008. We have Professor Dr. Expert Randy Sheffin here in the studio with us today, and he's going to discuss with you about the case, as will Professor Dr. Ovidio Simeon. But first, Professor Dr. Sheffin, I was wondering, how do you feel about Al-Barakat's claim that the Council was not competent in passing the contested regulation?
So, first of all, Mr. Mafaz, I wanted to thank you to inviting me here and having the opportunity to speak some words about this important case. So, to respond to your question about the competence of the Council to pass such a regulation, I was already speaking behind cameras with Professor Dr. Expert plus Ovidio Simeon, and we agreed both on the topic that the Council had a legal basis to act and to implement such a regulation, especially like foreseen in Article 16 and the procedure from Article 301 of the EC Treaty.
Okay, so yes, that's very interesting. And I was wondering, Professor Dr. Expert Ovidio Simeon, do you really share these sentiments with your colleague?
Alright, so first of all, I'd like to compliment you, Mr. Moderator, and Mr. Sheffin on their suits. They are really amazing. And I'd like to say that I completely agree with my colleague on the facts about Article 16 and Article 301. But I'd like to move a little more to substantial problems about the fundamental rights issue, because there's an issue about the due process and the rule of law here that we definitely need to discuss.
Yeah. I agree with you 100%. But before we move on, I just want to say I'm not 100% sure about council competence, but since you're both the Professor Dr. Experts, I'll defer to you. And yeah, let's move on to fundamental rights. So, Professor Dr. Randy Sheffin, do you have anything to add?
Thank you, Mafaz. Yes, I would like to add some words to that, especially concerning the fundamental rights. So, fundamental rights are tremendous importance inside of the European Union, and especially the notion of the rule of law. So what does it mean, the rule of law? Well, in the Kadi case, the rule of law reflects by firstly getting to know what one is accused of, what evidence is there. Secondly, the right of a fair and independent judicial review, which means one has to get heard. And lastly, there are other elements, like the right to have a lawyer, but I'm gonna not go in depth on these terms. I just want to stress out how important fundamental rights are, and that the court couldn't decide differently in this Kadi case. Why, you're gonna ask me? Well, it's easy. Fundamental rights, especially the rule of law, are core values and elements of the Union and the treaty.
Yeah, well, I pretty much agree, but the fundamental distinction is that... No, I agree.
Yes, no one disagrees with you guys that fundamental rights are really important, but I have a question. I have a tough time reconciling how one can let someone do this on a European level when these obligations arose in the UN, and when there is such a thing as Article 103 of the UN Charter and Article 25 of the UN Charter, which give primacy to UN law. And the UN also has stuff like the Convention on Human Rights, the Convention on Socioeconomic Rights. Aren't there methods of fixing this at the UN level?
So Mafaz, you went out for them. And all I could take out of it is that the primacy of UN resolutions above European Union law, and how the court could overthrow it. Well, I have to tell you that for me, that's my personal and expert view. I think that the UN, especially the UN, is one of the most political institutions in international law on the world. And the European Union, the Court of Justice of the European Union, has to be in charge to tackle these resolutions. Because if we remember the case, the court doesn't attack the resolution in itself. It attacks the regulation the Council passed to implement this resolution. So if we are like just were to taking the text, like you mentioned in the Charter of the United Nations, by letter, there would never be any disapproval with the Security Council of the United Nations. And I strongly disapprove that. I think there has to be some institution, and there's no better, in my humble opinion, than the Court of Justice, to interact and to see and to do a judicial review. We are talking here about really, that's the main point you guys have to get. I'm addressing myself to the audience now fast. The rule of law is a core value. It's not just something written in the treaty. It's a tremendous importance. Imagine it wouldn't have been about freezing assets, but it would have been being imprisoned, never get the chance to get hurt, never getting told what happened, just because Article no tells you, yeah, the UN Council's resolutions should have primacy over union law. No, I strongly disapprove that. And further, after the case, the important case of Kadi, what happened? Well, what happened? I will tell you what happened. It happened that the Security Council changed and reinforced its mechanism of examination. But in the second Kadi case, yeah, you heard right, there's a second Kadi case, even a third one. But in the second Kadi case, the General Court, what did it do? Exactly. It rejected it also rejected the mechanism of the UN. It is not fulfilling the right values of rule of law. It is not giving. I'm losing myself, so I'm gonna readdress to Elvidio, who is really expert on the second Kadi case.
Hello? No, I'm not busy. What? Stop crying. What do you mean you're pregnant? What? A video? Did you have something you wanted to say?
Alright, thank you Mr. Sheffen for all this giant speech, because it actually allowed me to take giant notes. So, I want to talk a little about the practical side of this story, right? Because all this legal mumbo jumbo nobody really cares about. So, here's the first point I wanted to make. It's the fact that I don't think it's the place of the CGEU to decide what to strike down on international treaties, because otherwise member states of the UN will never know when the treaty actually applies and when it doesn't. They'll just sign something and then they'll say, maybe a regional court at some point will decide to strike this down, so we can't really rely on this, but we can't really rely on that either. So that's the first point I wanted to make. And the second one is the political difficulty. Because as Mr. Sheffen rightfully said, it's a political issue. And when it comes to political issues at that level, which is a very high level in international institutions, you can't just go over something that was decided at such a high level just because you don't like it. And this shows in Kadi 2. The Commission kept Kadi on the list actually and gave an argument which isn't exactly decisive in any way, because it just said that the Kadi 1 case doesn't require more information to be given to Mr. Kadi. Actually, that's just a decoy to say that in fact the Commission doesn't want to take Kadi off the list, because it's difficult to make things advance at such a high level politically. And that's for the political side. And finally, my final point would be that there is a problem of discrimination, in fact, because if just one side of the world can strike down things that the court of that side of the world doesn't like, what about the other continents? They don't have any way to protest this. So I'd say that it's important to have something at UN level to make sure that everything is centralized and that everyone has the same rights. And with that, everything is included. Bye.
So, thank you for joining us today at ECNA. We hope you enjoyed your time with us. We had a lot of fun creating this stepping point for everyone to discuss this case. And we hope we inspired you to continue this discussion, preferably with a law professor. And until then, good day.